You're watching Morning Live. Thanks so much for being with us. Now, the Parliamentary Committee for Section 194 inquiry into suspended Public Protector Advocate Busisiwe Mkhwebane's fitness to hold office will continue with its hearings this week. Now, that is according to the committee's chairperson, Qubudile Dyantyi. Now, on Friday, Advocate Mkhwebane's legal team's mandate was terminated due to funding issues. And this after the Public Protector's Office sent a letter at the beginning of last month of its intention to withdraw legal services funding from the 1st of April due to financial challenges. The Committee for Section 194 rules state that it must afford the holder of a public office the right to be heard in their own defense and to be assisted by a legal practitioner or other expert of their choice. So to help us discuss what all of this will mean for the inquiry going forward, we are joined now virtually by Mpumelelo Zikalala from Zikalala Attorneys. Thank you so much for your time. Welcome to Morning Live.
Good morning to you, Sakin, and also to the SABC viewers.
So this is an interesting one. The committee basically saying that, you know, the work of the committee needs to continue. And unfortunately now there's the added issue of the Public Protector's Office saying that they can no longer foot the bill for the suspended Public Protector's legal team. So what do you make of this development?
It's a huge blow in which is going to cause very long delays in terms of this matter being finalized. Now, let's remember that the right to legal representation by the Public Protector was confirmed by the Constitutional Court, in which it says, in your rules in which you are going to make Parliament, just make sure that you are able to afford the Public Protector with legal representation. Now, if there are any instances in which the legal representation is not there, it means no proceedings can proceed where the legal Public Protector will be required to make any representation or make any submissions without the legal rep. Those instances or those periods in which the legal rep was not there can be void or removed from the record, so they can't be assessed in the overall assessment of whether the Public Protector participated in any acts of misconduct or does not have the capacity to hold the office of Public Protector. So it's going to cause long delays. A solution needs to be found by the department. And once that has been done, they must be cognizant that this matter must be finalized as soon as possible.
And that's the interesting bit, because the inquiry through its chairperson basically stating that the hearings will continue this week as planned, and stating that it would be unfair to the Public Protector and to everyone involved to actually stop the process at this stage, as you point out. But at the same time, the advocate representing the suspended Public Protector, Advocate Dali Mpofu, has basically said that they no longer have a mandate. So how is this going to play out?
It must be looked at from in the sense of saying, who's to blame for the legal rep not being there? Is it the Public Protector? And the answer is no. The Public Protector is a willing participant. She's saying that I'm willing to come to the committee and be able to spend the whole day or the whole week as I've done previously, provided that I have someone who's going to protect my legal interest. Now, if you say to me you can't pay that particular individual, it means that I cannot participate. Yes, I'll be there out of the respect of the orders that have been issued by the chairperson, but in terms of active participation, then I won't be there. Let's look at the intention of why legal representation was required. It's there to protect the legal interest of the Public Protector. Yes, she may be an experienced legal practitioner, but it is not advisable that you should represent yourself because you're too entangled in the matter. You're going to think things through emotions and not through rationality. How you're going to be able to raise instances where you want to raise point of orders, for example, where you say, I didn't say that in my examination in chief. How are you going to do that without someone who's going to be able to state that eloquently for you? So it's a huge conundrum in which they should try and fix, but the only way of fixing it is to say, provide temporary relief. We'll find the money where you're going to find it, just to make sure that you're able to finish this process. Maybe what they ought to have done at the start of the proceedings is to say to the Public Protector, we realize the obligation that we've been given by the Constitutional Court. However, it's not going to be a blank check. We're going to allocate to you a certain amount of money in which we think would be money which will be able to take you through this proceeding from point A up until point Z. Go and utilize it in the best way you see fit. If it comes at the end of the day that the money is no longer there, unfortunately, us as the department or as the public protector will not be able to carry through with those particular instances. Now, our laws or our courts have been very clear in terms of saying, yes, we do realize the responsibilities which have been provided to by the state, but they are not unlimited resources. There have got to be a limit somewhere, somehow. If you did not state that at the start, that's why you're going to have a problem when you're supposed to move on now. Another problem which causes all of this is that if you take a process that is meant to be quasi-judicial, meaning that there's supposed to be rules and procedures in which are almost similar to that of the court, and you use them in instances or in systems where they can't really apply accurately, you are going to have this type of issues. One example of that is if I would ask the question, who is the presiding officer or the decision maker at the end of the day when it comes to this committee? Is it the chairperson or is it the committee in its entirety? If it's the committee in its entirety, what sort of methodology are they going to use to check whether the public protector engaged or participated in acts of misconduct? Are there written rules that say, if you do the following things, you are going to participate in acts of misconduct? The expertise and skills when it comes to that particular assessment, how are they going to do that? I can't go to a surgery and assess whether a neurosurgeon is performing a surgery accurately because I'm not a doctor, I'm not qualified to be one. So whether I'm doing something wrong or doing something right, I wouldn't be able to know. If you take that away from these proceedings, that's why you are going to find problems and you are going to find these never-ending delays, which probably are going to continue today in instances where someone is supposed to act in a particular manner in which they failed to do so.
So what is the way forward? And failing to find, a solution to this, what would that mean for the work that's already being done and for this particular sitting going forward?
To try and make sure that there's value for money in the sittings, the committee should come back and say, let's try and look for money wherever we're going to find it to make sure that we're able to proceed. That's the first one. Secondly, let's change the manner in which we are conducting these proceedings to effect finding one, in terms of saying we have never sat in this type of proceedings. We are learning still, and you want to know what is a perfect example of a public protector, not a superhuman public protector that has no fault. If we're able to compile those rules, it's simply for you to say, on the next occasion, when you appoint the next public protector, probably next year, then you are going to say, in order for a public protector to act in the best way we know how, to be a fit and proper public protector, these are the instances and the manner in which they ought to behave. It was due to the fact-finding mission that we had done as a committee, what we were able to extract from the evidence that was there, and that is what we are basing our processes from. And then let's go back and check, are there any legal loopholes procedurally or substantively that we need to take care of so that if ever this matter were to go to court as taken on review by the losing party, then we are not found wanting by the court. Because the worst thing that can happen is that after all this time, after all these funds have been given and been submitted or been paid, you go to a court of law and the court of law says that we are setting aside the findings of the committee because there are certain procedural aspects which are not followed, of which one could be one of today's one if the committee would proceed without the legal representative of public protector being there. And if it means you've wasted time and you've wasted money and you don't have any value in which there is to show for it, it would be a perfect example of a fruitless and wasteful expenditure when it comes to these proceedings.
So the next question is, of course, where could that money possibly be found? Because the public protector herself said she is unable to fund this, firstly because she didn't bring herself to this committee, she says, but also she says that she simply cannot foot that bill because she's been slapped with a cost order in other proceedings. So where could the committee possibly find the money from?
I think the Department of Justice will have to scramble and see what sort of environments they can be able to do or reallocate certain funds so that this particular process can be able to move forward. Or maybe come back and say, Parliament, you're the one that started this particular process. This is your committee, actually. This is going to assist you as much as it's going to assist us, the Department of Justice. However, you are the sole custody of these particular proceedings. You've started them, you are presiding over them, you are controlling the manner and the sittings that have been taking place. Any instances in which you've been taken to court, it was due to the sequence of events that took place within that particular committee. It's an expenditure that you are going to have to find or be able to foot the bill for. We can't do it on your behalf. You have to do it because you are the custodians of this particular committee. By the way, it was started by you, Parliament. You are the one that says we are going to create the rules. We are going to create the committee which is going to sit in, the number of hours which are going to be there, or you ought to have known that these are the type of proceedings which were going to take place. But most importantly, from the planning side, because this thing is something that has never been done before, you ought to have known that it's not going to take as much time or the time in which you have allocated it in. Due to the vast amount of evidence that have to be brought in and the manner in which things have to be done. For example, whenever a witness goes into that particular box, there's examination in chief, cross-examination and re-examination. That on its own can even take 1 day for a single witness. Worse when it comes to the public protector, because it's going to take more. She hasn't even undergone a cross-examination by the parliamentary representative of the evidence leader. So that's again going to take some time. And you can't blame the public protector for that. As she correctly stated, she did not bring herself to the parliamentary committee. She was brought there at the instance and invitation of the committee, and she must be afforded some type of relief when it comes to the paying of the legal fees, because it's not due to her own violation that she's there.
So with all of that at play, just finally, what would ideally be the way for things to unfold today? Should they proceed, the committee, or should they halt this work until the legal team can be paid? Because the other question is, if not this legal team, then what? Because I think I read somewhere that Advocate Dali Mpofu and the legal team had said they'd already taken on other work because they don't have a mandate beyond the 31st of March.
The ideal situation is to say, let's not proceed if we are going to hear any evidence that would need you to have a legal representative next to your side. If we are going to continue, it's either going to be in-house issues in which we are discussing internal things as the committee that has nothing to do with the evaluation of the evidence, or let's have a discussion of saying where are we going to find the money in order to find the legal bill of the public protector. Now, the danger in getting a new legal team to be part and parcel of this proceeding is that they are going to have to start from scratch with the evaluation of what was submitted from day one. And if there are instances in which they think that they can be an addition, for example, the recalling of witnesses, they may as well make that application and say, can we recall witness number 2 or number 3 or number 7? Because we think that there's certain information which will be beneficial to the committee which was not asked to them. Now, there's further delays, there's further cost. So it's highly advisable that when the parliamentary committee is sitting today, they take cognizance of the constitutional right, and which was further confirmed by the Constitutional Court, of saying that the public protector cannot appear on her own. Number 2, they must then find a way or brainstorm as to where they're going to find the money to further foot the bill of the public protector, and then try and make sure that they're able to curtail whatever is outstanding of the committee, so that they don't skyrocket the legal bill of these proceedings to something that can't be attainable. Doing all of that, be cognizant that at the end of the day, whatever decision in which you are taking may be taken on court to be reviewed, and if it is found that you have acted in an unlawful manner, you may be part and parcel of engaging in fruitful and wasteful expenditure.
Well, we're going to have to leave it there, and looking forward to see how they will actually handle this. But thanks so much, Mpumelelo Zikalala, legal practitioner at Zikalala Attorneys, giving us his legal analysis on what's expected to happen today. And of course, in the coming days, after the Public Protector's Office withdrew the legal funding for our suspended Public Protector, Advocate Busisiwe Mkhwebane's legal representation from the Section 194 inquiry from the 1st of April. You're free to let us know your thoughts as well at Morning Live SABC.